The primary concern of the jurors who heard the testimony in this case, when I spoke with them after the verdict, was, will there be changes? Change is needed. Will some of these supervising officers be fired or disciplined? Is what we saw normal for the Minneapolis Police Department and the Bureau of Criminal Apprehension? How will this be prevented from happening again? Why are officers more concerned about their personal safety than the safety of the public, especially in such a low-crime neighborhood? Why was there so much discussion of ambushes? Why should a civilian have to be afraid of approaching a squad car? What about the motto on the car door, to serve with compassion? Why were Noor and Harity so reactive? What was their training? The jurors were particularly concerned with Officer Harity's statement that his priority was making sure he did whatever he had to do to get home safe each night. Jurors remarked that they thought the priority of the police was supposed to be to protect and serve the public. No one who heard the testimony in this case or who works in the criminal justice system can question the difficulty of a patrol officer's job or the dedication of the majority of the police and first responders. But here, something went very much awry. The victim's family and some of the witnesses, including some officers, have expressed concerns. A large amount of taxpayer dollars will go to Australia, but Minneapolis residents await the promised transformation, and the questions of the jurors remain unanswered. What has changed? What will change so this does not happen again? How does the department address officer safety without jeopardizing public safety? The jurors and the people of Minneapolis need and deserve answers. As Ms. Sweezy noted, the actions of police officers are subject to a very high level of scrutiny. They have a lot of power. They are sworn to uphold the law. A high level of scrutiny is appropriate for those with the power to stop, arrest, detain, and the authority to use force, including tasers and guns. The defense in this case urges a departure to probation. In support of that, they argue that Mr. Noor is particularly amenable to probation. I have received numerous letters about what a kind and helpful person Mohamed Noor is, and it certainly appears that he has been helpful to many people and to the community. However, according to the very thorough pre-sentence investigation authored by Ms. Magnuson, Mr. Noor denies the need for services and has not engaged in any services despite maintaining that he is seriously affected by the trauma of July 15th and carries it with him every day and deals with it daily. Mr. Noor continues to maintain there was no choice but to take the action he took, and that he was justified in firing his weapon to protect his partner. While he is clearly saddened by Ms. Rustrick's death, he does not take personal responsibility for making an erroneous decision to fire a gun at her. He has not acknowledged that he could have handled the situation any other way. He and his partner continue to maintain that her presence near the vehicle justified their extreme response. Mr. Noor has not acknowledged that he incorrectly assessed the situation. Rather, he states in the pre-sentence investigation that he had pure intentions and, quote, deep down I felt I was justified, end quote. This even though he admits that within minutes he could see that Ms. Ruszczyk posed no threat. There is no basis for a dispositional departure. There is remorse for the consequences of Mr. Noor's actions, but not for the actions themselves. As long as there is continued justification of the choices made, there is no likelihood that Mr. Noor will change his views or act differently in the future. There is no particular amenability to probation. As Ms. Sweezy noted, the staggered sentencing proposed by the defense, or the therapeutic processes proposed by the defense, are not something we use in murder cases. The defense has also moved this court for a durational departure. That would be less prison time than the guideline sentence. The legal basis required for a durational departure lies in the particular facts of the offense itself. A durational departure is appropriate where the behavior in the crime is less onerous than similarly charged crimes. That is not the case here. Mr. Noor testified that he saw Ms. Ruszczyk, noticed the color of her hair and her pajama top, saw her right arm raised, aimed his weapon across his partner, and shot her. These facts are not less onerous than other third-degree murder cases. The act may have been based on a miscalculation, but it was an intentional act. We heard testimony from experts that trained police officers shoot to kill. Criminal liability is assigned in numerous situations for miscalculations based on extreme negligence. Officers are trained in depth about when the use of deadly force is justified. The jury in this case found that it was not justified in this case for Mr. Noor to use deadly force. Minnesota case law specifically does not justify departures from the sentencing guidelines based on a person's background, education, job history, family, friends, overcoming of past challenges, or past service to the community. The law does not allow lenience because somebody is a good person. It is not the job of the court to make a decision about whether a convicted person is a good person. Good people sometimes do bad things. It is the duty of the court to determine the consequences for the particular crimes committed. Based on the findings of a jury after a month-long trial, Mohamed Noor, I find you guilty of murder in the third degree, perpetrating an eminently dangerous act, and count 3, manslaughter in the second degree, culpable negligence, creating an unreasonable risk. I hereby convict you of those crimes. The sentencing guideline sentence for murder in the third degree is 128 to 180 months. With regard to count 2, I hereby commit you to the Commissioner of Corrections for a period of 150 months. You will receive credit for the 41 days you have spent in custody since this offense. You must provide a DNA sample as required by law. There is a mandatory minimum fine of $6,000. You may not use, possess, or transport guns, ammunition, or explosives. To do so could result in a 5-year mandatory prison sentence. With regard to count 3, you stand convicted of manslaughter in the second degree. However, I will not impose a sentence on this count because it is a lesser included crime and arises out of the same behavioral incident. Restitution will be reserved for 60 days. Mohamed Noor, I hereby remand you to the custody of the Commissioner of Corrections.